All right. Welcome, everybody. It is getting towards the end of the year. It is December 22nd. And we weren't going to have a podcast today, but then I got on the phone with Doug and I literally begged him to come on. Many of you know that the Elijah McClain verdict is set to be produced here at any moment. So, without any further ado, this impacts all of us in EMS. It impacts you as a leader, as a medical director, as a paramedic on the street. So, without any further ado, Doug, let me pass it over to you. And thank you so much for joining us.
Yeah, thanks, Peter, for inviting me, and thanks to everybody for joining in here, especially so close to the holidays. As Peter said, we are literally waiting for the verdict. The jury is out. They've been charged. They're deliberating, and there are charges of reckless manslaughter, criminally negligent homicide, and assault against two paramedics. There have been other criminal charges against paramedics for drug diversion, vehicular cases. This is the first one we're aware of that relates directly to provision of patient care. What is most significant about this case is that the lines between negligence and criminal conduct are completely blurred. The prosecution's theory is that deviations from clinical protocols regarding the excited delirium, which is, of course, a diagnosis that has fallen out of use, and the administration of ketamine, that deviated from the protocols and the medical standards of care and constituted homicide or manslaughter. So the fact that deviation from medical protocols were attempted to be criminalized in this case, that is really the huge issue here. Every time we have deviations from medical standards of care, we call that malpractice, negligence. The worst that can happen is a civil suit with a payment, right? Usually by an insurance carrier. There was that in this case, by the way. In 2021, the city of Aurora settled with the McLain family for $15 million, which included both police and fire because they're both within the same city government. So we've had the civil settlement, but then, after some political involvement, the state attorney general's office filed these charges. And really the essence of their theory was that the deviations from the medical standards of care constituted homicide or negligent homicide in this case. So the blurred lines between negligence and criminal activity or criminal conduct is really the huge takeaway from this case. We are waiting for this verdict. As I said, the jury deliberated all day yesterday. I think most of us expect that the jury will want to render a verdict either way today by the end of the day, because they're not going to want to come back after the Christmas holiday. Who knows? We're not in the jury room. I've watched most of the trial in real time. And I can tell you that I think, having given this a lot of thought, the verdict is going to be very personal to the two paramedics and to the McLain family, but the lessons belong to all of us. And I think the lessons apply almost regardless of what the jury's verdict ends up being. And I don't think an acquittal means that paramedics and medical directors everywhere should relax, just as I don't think a conviction means that paramedics and medical directors everywhere should be in despair. I think what we need to do is we need, like any evidence, whether it's in research or that comes from court, right? We need to take that and glean the lessons from it and incorporate it into our practice. And we could talk for hours on each individual issue of patient assessment, where you park the vehicle, do you bring the monitor to the patient's side, what the protocol provides. We could talk in detail about that, but I'll tell you what I think are the 3 or 4 big picture, high level takeaways of this case. One is that, medics need to put, and this, I know this sounds like a platitude, but we need to put the interest of the patient first. Yes, that sounds like a platitude, but it's not. It's a lot easier said than done, especially in cases involving law enforcement. One of the principal allegations here is that the medics did nothing more than assist law enforcement with detaining Mr. McLain. He was not under arrest, by the way. This was a stop of a person walking down the street wearing a ski mask in the summer. And, somebody called 911 alleging it was suspicious. and it de-escalated from there. I should say escalated from there. It became what it was. But the point is that the central allegation is that the paramedics basically did what the police asked them or directed them to do, which is to hit this guy with ketamine, right, to assist us in restraining him. Anytime that decisions are made regarding any intervention, and here we can talk particularly about restraint and sedation, anytime those interventions are done, they have to be in service of patient care, not in service of law enforcement. So I think that is probably one of the biggest takeaways from the case. The second one is that I see is the relationship on a broader scale between EMS and law enforcement. And what I mean by that is there were allegations in this case that paramedics did not have full access to Mr. McLain, and that police refused to release the handcuffs until Mr. McLain was moved to the stretcher. And first response, the paramedic engine was there well before the ambulance, and it was those paramedics that ended up getting charged. When does a law enforcement incident become a medical situation, right? When should law enforcement stand down, and when should EMS speak up? If there would have been clips or sound bites on that video where the medics would say things like, "Hey, he's ours now. We got him. Release the cuffs. We need access to the patient. We need to be able to assess him," right? None of which was on the tapes in this case. I think that would have been very powerful evidence for the paramedics in their defense. Instead, just showing up and within 90 seconds of arrival, giving the patient ketamine without a full or detailed assessment, no cardiac monitor nearby, I think that's what created, a big chunk of the prosecution's case here. So, we need clearer guidelines for when a law enforcement incident becomes a medical scene or an EMS situation. And medics need to be assertive and speak up to basically take control of patients so that they can provide necessary clinical care. And that's much harder to do than it is to sit here and say, because the people with the badges and guns do tend to be very dominating when it comes to control of a scene. Third, and there's no, and let me be very clear, there was no express evidence that came up in the McLain case about what I'm about to talk about. But, these cases, whether it's the McLain case in Colorado, the Earl Moore case, which is a first-degree murder case against 2 EMTs, I'm sure we'll talk about that in a future webinar. That's not come to trial yet. Whether it's the Eric Garner case, the George Floyd case, the Tyree Nichols case, by and large, these involve white EMS providers and Black patients. And even though there was no overt suggestion or evidence in the McLain case, EMS needs to talk about its role in social justice, implicit bias, disparities in care, which are well documented in the clinical literature for underserved populations. All of those things need to be part of the EMS conversation. And then fourth and finally, I think, is this idea that deviations from medical standards of care and from EMS protocols can be criminalized. Will this lead to introduction of legislation that prohibits prosecutors from, applying criminal statutes to alleged protocol deviations for EMS providers? I don't know. We don't know what the legislative, the legal, the policy implications of this case will be. But the fact that and I said this right at the beginning, but the fact that deviations from medical protocols can be criminalized, and I'll tell you that in the defense's closing, their argument was basically, look, there may have been problems in EMS care in 2019, how we looked at excited delirium and how the police stopped and detained people. This is pre-George Floyd, this was prior to all of that. That they were really attacking the protocols, right? Which I think as medical directors, many of you will go, well, isn't that interesting, right? Because, so the defense was saying, look, these protocols may have had their problems, but it was what the paramedics had to follow at the time of this incident. So the appropriateness of protocols themselves was really a subtextual issue in the McLain case, right? Now, the medical director was not a party in the case. He was not named as a defendant. he did come into court to testify about the protocol and the compliance with the protocol. But, the subtext of the case, and was expressly stated by the defense, this maybe wasn't the world's best protocol either. So we're not too far from the next step where can protocols themselves be on trial, right? Can a protocol be negligent? It's almost like the Nuremberg defense. Well, we had to follow the protocol. Yeah, but that was the wrong, it was an improper protocol to begin with. So that was a subtext of the McLain case. So just, those are really briefly what we see as the big issues. Like I said, I have all the alerts set up on my phone here. We might literally be getting a verdict any minute. We've been sort of blogging about this case on LinkedIn. So I would say quickest way to find out what's happening is just to connect with me on LinkedIn on my profile or my firm's page, Wolfberg and Worth. We already have our posts on this pretty much ready to go, awaiting the final verdict. So as soon as that comes out, which could be today, we'll push that information out. So I wanted to leave a few remaining minutes for comments or questions if folks have any.
I'll start, and I would love for other people to jump in. Doug, I've been listening as well, and I didn't hear anything about the fact that this person, Elijah McClain, may have died because of the chokehold, if you will. They're putting a lot of the blame on the ketamine. They're putting the spotlight on it. They gave him 500 milligrams. It was a little bit more than his weight-based dose if you get his actual body weight. We know that ketamine can be given in a tenfold overdose and still be safe. Why is the other half of that not coming up in this trial?
You mean the law enforcement role, like the carotid hold and that kind of stuff?
Right. In other words, asphyxia as the real reason for his death, instead of what the coroner put, which was the cause of death was ketamine, which I don't believe.
Well, yeah. I mean, look, I think everybody on this call understands that the difference between a 500 milligram and a 420 or even 300 milligram dose of ketamine is not toxic, right? And there was significant testimony because in many ways, ketamine was on trial in this case. I think the overwhelming evidence suggested that ketamine itself was safe. I'll get to the question about the chokehold in a second, but very importantly in this case, after the prosecution rested, the defense always makes a motion for judgment, a directed verdict, or an acquittal. Prosecution failed to prove its case. Please acquit our clients. That never works. But one of the issues that the court had to consider was one of the charges was assault with a deadly weapon. The prosecution alleged that ketamine was a deadly weapon. The judge very importantly ruled that ketamine was not a deadly weapon. All right, so that is a vital ruling that came out in the middle of this case. The defense did raise the application of the carotid hold by the police officers, and more importantly, they raised the fact that this information had been withheld from the paramedics. I think the defense made a very effective argument in closing that the paramedics, now everybody looks at the body cam and sees the hours of footage and all the expert testimony. But at the time the paramedics came, they were given a limited snapshot of information. Law enforcement specifically did not inform them that they had applied a carotid hold. I would note that 3 police officers were also criminally charged. Their trials are over. One of the 3 was convicted. The other 2 were acquitted.
Interesting. Okay, great explanation. Let's go to Dr. Matt Levy from Johns Hopkins. Matt, please go ahead and live. We cannot hear you for some reason.
All right.
Here you go.
All right. Hey, good morning. Hey, Doug, thank you. That was,
Hey, Matt.
as always, very impactful and thoughtful. Yeah, I think we're all waiting with bated breath to see how this plays out for the reasons you said. The discussion about ketamine and the criminalization of a drug is something that we'll be studying and talking about for years after this, no matter how this goes. My question for you and for the other thought leaders on the call is very simply, we, like any other ALS intervention, we know that with any therapeutic intervention, there's risks and there's benefits. And I think we need to slow the roll, whatever happens here, however this outcome is, we need to slow the roll to think about being about just changing the way we approach ALS education, training, and readiness to focus on being ready for whatever's going to happen next, just like we would in airway evolution, just like we would in anything else like that. So I think if we can look for the silver lining in this cloud, it's really to take that mantra and say, hey, we just have to do a better job. And you said it, and this is what I wanted to reiterate, Doug, is you said this point about being very focused on what we're saying on body-worn camera. So people can hear, okay, he's mine now, he's our patient now, we need to do X, Y, and Z. We need your help to treat our patient. I think we will see and hopefully experience more scripted or more very intentional statements like that, so we can slow the roll. My last comment is where we seem to get into trouble is when we break roll, when medics try to be cops and cops try to be medics. As the medical director for multiple law enforcement agencies and someone with a law enforcement background, I stand with law enforcement, but I would say that we have to stay in role. And it's just that important. I think reminding people that for the educators on the call as we build into our training is going to be important too. So thank you, and wishing everybody happy holidays. Thank you.
You too. Boy, I'm not sure I could say any of that any better. Honestly, I think the issues of staying in your lane are critical. The issues of the assessment and having the tools of the trade by the side of the patient, that was a big issue in this case. No monitor present, right? No airway kit. I think those were all outstanding comments.
Okay, let's go. We only have 4 minutes with Doug. So Marv and then Ken. Go ahead, Marv.
Okay, very quickly. 4 years ago, we did not like the term excited delirium, completely removed it, went to the term combative, which describes the patient, agitated, which is the patient. And we completely set up a pathway for using ketamine. We've used ketamine for a very long time, safely. So the term dispatch is no longer excited delirium, which we had to get LE educated on. The term allows no medical direction from law enforcement. They are not a medical authority. And we document clearly what our pathways are in our protocols. And then we describe what is required. It's early in the morning here. We describe what is required when you give ketamine for monitoring and documentation. And thus far, as I said, when in question, we use medical control. We don't use that for every call. But thus far, we've been successful. Yes, some people are sedated, but that's just the way it is. But thank you, Doug. It's good to see everybody, and happy holidays to everyone.
Great.
Thank you, Marv. Ken, go ahead. Dr. Shepke.
Doug, thanks for that. It was very helpful. Years ago, when this first started, we changed our protocol so that before the paramedics could administer ketamine for a patient with excited delirium or combative agitation, I don't really care what term you use, so that they have to actually call the medical director to get physician orders. So now we're not attorneys, but I'm assuming that would give extra coverage for our paramedics so they don't end up on this. And from the physician standpoint, it ensures that it actually has been an evaluation and we've considered the alternatives. Do you think that provides a level of protection that had these paramedics had that would have helped them in here?
Yes, I do. I think it would also have the effect of adding another seat at the defense table, to be honest with you. Because who knows if they would have called for online medical control and simply said, we're here, cops say he's been fighting them and he's got, superhuman strength and all these other allegations, and the medical director just said, yeah, okay. It would still be incumbent upon the medical director to say, is your cardiac, all of these other things, that were done pursuant to protocol. Look, I think more medical control in these situations is better. Colorado passed a law after the McLain case prohibiting the use of ketamine in the presence of law enforcement by statute unless certain exceptions are met, right? If we don't want legislators to start legislating the practice of medicine, which we sure as hell don't, then we do have to self-police in these kinds of cases. And I think bringing online medical control into it, as you suggested, is another good way to do that. Last thing I just want to comment, I want to go back to what Matt said, and that is the issue of cameras, right? I mean, we know that many police are wearing body-worn cameras, but even if we don't overtly know a camera is present, if we always act as if we think one might be somewhere, right? Some bystanders holding up their cell phone, a traffic camera overhead is recording it, whatever it is, right? Security cams at a place of business or somebody's camera in their house. If we act like one is always on us and we would be proud to see what we did on the 6 o'clock news, then that's going to go a long way to preventing the kind of liability we saw in the McLain case. So I think we always act as if there is a camera present, and we're in a way performing for the judge, the jury, the prosecutor, and the 6 o'clock news. And if that performance, I don't mean it so callously, but shows a first and foremost primary devotion to the patient's well-being, I don't think you're going to be sitting at a defense table.
Great. Well, very well said. We have Colorado Medical Director, but it's 11:20. Doug, one more question, or you got to go?
One more. I'll go to 11:21, and I really have to go.
Dr. Applebaum, go.
Hi. And not as much a question, but just more the downstream stuff of what's happened here in Colorado. So we have the law regarding ketamine, and I've met with the legislator who was the one who put that forward, and she firmly believes that she's saving lives. Unfortunately, it's going to have the opposite effect. What we are seeing is more first responders getting hurt because we're not able to adequately restrain or sedate people who are violent. And that's more within the Denver health spectrum, so downtown Denver, more the urban area. But that's become a significant downstream issue. So we're actually, for 2024, the framework for sedation is changing again. But I don't know if you have any commentary about that in terms of the law of unintended consequences there, if you would.
Well, I'm saddened to hear, but not surprised, of the impact that passage of a law like Colorado's ketamine law has on the actual practice of paramedicine. Those are, I think, these laws are well intentioned, and we operate in a political environment, especially when something of the nature of the Elijah McClain case happens, or if you're George Floyd in Minnesota, or if you're Tyree Nichols in Tennessee. Right? These are the kinds of things, the political responses that we could expect. I think if we can start to capture empirical data that demonstrates the impact that these laws are having on the practice of paramedicine, if there are increased cases of injuries to practitioners, if there are disparate outcomes in cases of patients who are in police custody who are not getting treated for the combative behavior or whatever it is, then I think we need to go forward with that and make a policy case that these laws need to change. And we need to put paramedical practice and EMS medical oversight back into the hands of medical directors and clinicians and not elected officials. Because I'm sorry to hear that, but I think it's predictable. As you said, the law of unintended consequences, we need to make our case because, that is an unfortunate consequence of this case. And now I really do have to go, but I promise, Peter, that I will come back and talk about this case again if you'd like me to, or answer questions. And unfortunately, we've got the first-degree murder case in Illinois. That's not on the trial calendar yet, but when that goes onto the trial schedule, if it doesn't plead out, that will be another one to watch.
You're amazing, Doug. Thank you so much for your time. Great to see you.
Thanks.
Happy holidays.
Happy holidays to everybody.